when you look at all the range of environmental organizations out there who are trying to protect the planet in one form or another, they do have some very strong things in common. Sometimes they don't act that way, which is what my job is, I think, to talk about. One of the things that we do, I think, all try to do within the environmental movement is to enforce what few pathetic environmental laws we do have in this country, because the government is not enforcing them. I mean, that is what we just heard, and it is obviously true. So many environmental organizations take it upon themselves, one way or another, to enforce the laws that exist. And they can do that, we can do that in a number of ways. You can do it through litigation. There's certainly enough lawyers out there in the environmental organizations that are trying to litigate to mandate the federal agencies or the state agencies to enforce the laws. You can do it through bearing witness. You can do it through basically calling media attention and other public attention to the fact that these laws aren't being enforced. Or you can put your body in the way of those who are trying to destroy the planet. All of those are valid tactics. I used to be the director of Greenpeace US, and Greenpeace, while it avoids property destruction, does engage openly and confidently in nonviolent civil disobedience, which we internationally call bearing witness. It is a way to bring media attention to the crimes against the planet. Between 1971, when Greenpeace was formed, and 2001, I left in 1997, so between 1971 and 2001, Greenpeace regularly took inflatable boats and blocked nuclear submarines, got in the way of nuclear missile tests, got in the way of whaling ships, got in the way of chemical shipments, shipments of hazardous waste, and so on. We never once in those 30 years faced felony charges anywhere in the world. Never once. After George Bush became president, in August of 2001, we're not talking after September 2001, in August of 2001, a group of Greenpeace activists blocked or entered the waters, tried to block, and did delay for 40 minutes anyhow, an illegal test of the Star Wars missiles that were being shot off somewhere near Vandenberg Air Force Base. They got into the water, they were there openly enough that the test had to be delayed. They were charged with felonies. They were facing 11 years each and $500,000 in fines. The missile test, as I say, was in direct violation of international law. However, Greenpeace, because this came to trial, this was August of 2001, because it came to trial after September 2001, after September 11th, Greenpeace was looking in the face of a very changed country, and certainly a very changed legal climate, where simply being called, not being charged with, but being called terrorists was all of a sudden upping the ante dramatically. And in the face of that, Greenpeace agreed to a civil injunction where, as an organization, they agreed for 5 years to not go near any missile tests in any US naval or Air Force facilities. They also, the 17 pled to misdemeanors, but I mean, that's kind of comes with the territory. Anyone who works for Greenpeace pleads to a lot of misdemeanors. That was in January of 2002. In April 2002, Greenpeace activists boarded a ship in the harbor of, it was actually, I think, 6 miles out of the harbor of Miami, that was bringing in illegally cut mahogany from Brazil. It was illegally cut under Brazilian law. It was being imported illegally under US law and under international law. They boarded the ship just to hang a banner. I mean, what does Greenpeace do, right? It hangs banners. So it boarded the ship in order to hang a banner. Those activists were arrested, they were held by the Coast Guard, they were charged, they were, let go for time served, and they were gone. 15 months later, Greenpeace, the organization, was indicted by John Ashcroft and the federal government for boarding a vessel before it arrives in port and conspiring to board a vessel before it arrives in court, because boarding the vessel is a misdemeanor. Conspiring to do it is a felony. So the organization was now being charged with a felony. This law about boarding a vessel before it arrives in port was a law that was passed in 1872 to prevent prostitutes from brothels to come out and board ships before they actually made it into port. It had been used twice in the years since 1872, and in both instances the judges had thrown it out as a joke. It was called sailor mongering, my favorite term. So, in this instance, I think Greenpeace had calmed down a little bit and learned the lesson of the new era, and decided to fight rather than to plead to anything. And so they fought the charges. They put front and center the fact that the mahogany was illegal, that importing the mahogany was illegal, that it had landed, then that same ship had gone on and offloaded the mahogany in Charleston, South Carolina, and it had gone out into the marketplace. And so they basically made it very clear that they were going to put that front and center as their reason for sailor mongering. And they also made a joke of it. They also got every environmental organization in the country, as well as the ACLU and Al Gore and a few others, to say how absurd this was, and dangerous it was, and chilling it was for the organization to be prosecuted, because not only was Greenpeace going to be fined, I can't remember the amount, it was like $100,000, but they also were going to lose their tax-exempt status, which is a valuable commodity for environmental organizations of a certain sort. Some of them don't bother with that kind of corporate structure. So 2 years later, the case was thrown out by the federal judge in Miami, the federal district court judge, as it should have been. Shortly thereafter, the Rainforest Action Network received a subpoena from the House Ways and Means Committee to submit all of its records about all of the civil disobedience in which it had engaged, with the names of all the activists who had engaged in civil disobedience in the name of the Rainforest Action Network for the last, I forget the term, I think it was since its inception, but perhaps not. Now, think about that for a moment. That's the U.S. House of Representatives Ways and Means Committee is subpoenaing records about civil disobedience from the Rainforest Action Network in order to test the validity of their nonprofit status. This is what our Congress is doing. Rainforest Action Network went through consulting lawyers, as people do, and unfortunately the lawyers advised them to comply with the subpoena, which they did to some extent. They redacted, as we say in the law, the names of all of the activists, but they did provide materials as opposed to just saying to the House Ways and Means Committee, stuff it. And so, of course, Ways and Means comes back and wants more and wants more and wants more. The only thing that has stopped that investigation is that the House of Representatives has a few other problems. Their minority leader just got himself indicted, and things are going badly in the House of Representatives. So they're a little distracted at the moment. Whether they will come back to this or not is a question. So far, nobody that I know of, and maybe you know differently, has actually been charged with domestic terrorism as an eco-terrorist or has been charged with anything called eco-terrorism.
Yeah, I'm not aware of the name.
Yeah. I mean, despite all the language that we hear in the press, these provisions that could possibly be used in the Patriot Act about, quote, domestic terrorism have not been used against any environmental activists. And yet we continue, and the word eco-terrorism appears nowhere except in the press. It is not a term that appears, I mean, it appears nowhere in the Patriot Act. It may now start to appear in these state laws that people are trying to pass and that just got passed in Pennsylvania. There's a conservative legislative group that is fomenting these laws from state to state, and we went through ours in Oregon 2 years ago and managed to kill it in our state legislature. That would have been even more ridiculous than the Patriot Act in terms of the breadth of definition of terrorism. It's if you are with anybody who is involved in acts dangerous to human life. I mean, it really got very carried away, but we were able to knock it down for then. But it's in the press that this so-called eco-terrorism stuff gets played out. 3 years ago, 4 years ago, Lord, now, a couple of students of mine were indicted for arson of a logging truck, and they were, in the press, indicted for eco-terrorism. And the Attorney General of the United States, as well as the FBI chief here, of the chief of the Joint Terrorism Task Force, as well as the U.S. Attorney here, had a press conference where they were about eco-terrorism. The word came up at least 5 times in the course of that press conference. They tried doing that as well when they got into court. And the judge, the federal judge, finally said, if you use that term one more time in my courtroom, I'm throwing out these charges. Because there is nothing in the complaint that says anything about terrorism. These 2 defendants are charged with arson, which is a very different thing. But of course, when you add on this terrorism panache to it, what do? You terrify other environmental activists. And that was exactly their intent. That plus the fact that back then, which was 2002, they were having a little trouble finding Osama bin Laden. So they had to find some terrorist somewhere. And that really is what is going on with all of this. It's like this face-saving thing. There are no arrests of terrorists who really are about to blow up anything of any human beings. So instead, they want to whip up this fear of terrorism because it is how they get to control the population. All right, we've been around that block. I think you've heard enough of that from all of us. But terrorism, in many ways, has become the new un-Americanism, the new Red Scare, as everyone's saying, the Green Scare now. And I think it would be very useful for us to go back and visit for a moment how activists in the 30s and 40s and 50s responded when the real Red Scare, the original Red Scare, was going on. Because we have, I think, a lot of lessons we can learn. I don't think we are reacting to the current climate as well as we could. And I think it's important that we talk about it together. One of the debates that went on within the Communist Party of the United States in the 1950s, when the Smith Act was in its heyday, the Smith Act prohibited belonging to a political party that advocated, again, sounds like the First Amendment, but wasn't, advocated the overthrow of the US government. Okay? So,
and still does, I think.
And still does, yes. So there was a Communist Party. You might not have read about that in your history books. It was a very active party. And a lot of people were indicted or were frightened about the possibility of being indicted under the Smith Act. There were 2 factions, basically, within the Communist Party. There was a real debate that happened of how do we respond to these indictments. People's lives were being turned on their heads. People with families, people with jobs, Their lives were being turned upside down. I'm not talking about the McCarthy hearings now. That was a different matter. This was real criminal indictments. That was just, well, okay. So, there was the New York faction and the California faction, but you don't need to know the details. But the first group of people who were indicted went underground. The reaction to that was that the American public figured they must have something on these folks. If they are hiding, if they are running and hiding underground, there's something truthful about what the government is saying about the Communist Party and about these individuals. The California faction took a look at that and saw what was going on, and it was a different group of people, different personalities, and they said, screw this, we're not going underground, we're going to go on trial. We are going to say who we are and what we believe and why we do what we do. That we are labor organizers, that we are community organizers who happen to believe that capitalism is the wrong economic system for this country, and we're going to talk about that in court. And we are also going to say that the First Amendment of the United States of the United States Constitution is a very, very precious thing to all of us. And that we stand by our First Amendment rights of association and freedom of speech, and we are going to stand up before the American public and before the judges and talk about it. And they brought about the finding by the Supreme Court that the Smith Act is unconstitutional because they stood up to it. And that's what we have to do. We have to be open, we have to be public about what we are doing and why we are doing it. When Greenpeace was willing to say, we boarded this ship, yes, because that mahogany was cut illegally, any jury would have acquitted them. They didn't even have to get to a jury. The judge directed a verdict. The other piece of this is that we have to stand by each other. It is true that different organizations and different individuals buy into different tactics of how we are going to enforce the environmental laws that our government is not enforcing, how we are going to stand up against those who are destroying our environment illegally and immorally. But when people are under attack, we have to stand together. And it doesn't mean you have to say, I accept their tactics. It doesn't mean you have to say anything about arson or anything about anything that specific acts that other people committed. You have to say the crimes against the environment are very serious crimes. These acts that people are committing are not terrorism. When my two students were indicted, we went to the faculty senate. I, with a couple of other professors, went to the faculty senate, and we got a resolution passed by the faculty senate, not because the Portland State University faculty senate has any influence with John Ashcroft or anybody else, even the city council, but because we wanted to force the faculty to go on record saying, and I'll just read you what they said. The Faculty Senate of Portland State University affirms that active political participation is not only the right but the responsibility of all citizens of a democratic country, that statements and actions of public officials which explicitly or implicitly question the legitimacy of political dissent or which gratuitously link activism to terrorism have a predictably chilling effect on the willingness of PSU students, faculty, and staff and all the other residents of Portland to exercise their democratic and constitutional rights. And then we called on all the public officials we could name to refrain and direct others in their employ to refrain from making any further statements or taking any actions which discourage political participation, dissent, or nonviolent political action, or which prejudice the right to a fair trial of any accused persons. We got the Portland State faculty to pass that. We have to go to all of our organizations and all of our churches and all of our official bodies and force them to take a public stand against calling these indictees and these defendants terrorists. They are not terrorists. They may be people who believe in anarchist acts. They may be people who believe in nonviolent direct action. They may be people who believe in direct action that is not so nonviolent, but they are not terrorists. And if we don't take that stand, then they will come after us next. Thank you.